Yeah, my question is actually for all of you. Congress doesn't write perfect bills. We avoid detail to keep majorities. We need to pass bills. Sometimes we think we're being clear and we're not. We are also can't see the future, and our decisions likely are going to have some unintended consequences. What are the courts and agencies going to do now that they have to determine best reading, and now what the Congress needs to do in order to be ready to react in those situations?
So, Senator, I can start answering that question. So, at least from the judicial perspective, courts have been instructed from the Supreme Court now to use really every tool in the interpretive toolbox to come down to give a statute its best reading. And this is familiar to the judicial task in non-administrative law areas of the law as well, like I don't know, like a criminal statute, for example. There is no agency for the courts to kind of throw up its hands and defer to what the agency view is. So the court has to come to a meaning of the law there. And post-Loper Bright, courts are under instruction to do the same thing in the administrative law context. So using statutory canons, precedent, dictionaries, what have you, coming to what the court's own independent judgment is about what the best meaning of the law.
Does any of you have a response?
I think agencies, too, obviously will have to do that. And research by Chris Walker at Michigan Law found that they already are. They're relying less on Chevron, the assumption that they'll get Chevron deference, and working harder to interpret the best interpretation. So maybe getting back to what Representative Schwartz was saying, the iteration, the back and forth, the communication between the executive and the legislative branch could help there.
I would just ask that, I would just again reiterate the fact that it's Congress that actually makes these decisions ultimately. So coming back to Congress if they need to, is one possibility. But again, making sure that you have the expertise and they have the expertise. It does not help to have hollowed out so much of the expertise in these agencies. How can you rely on them if there's no one there to pick up the phone, so to speak, which is happening. You know that, you see it. We expect more cuts to happen. And I think that's a real problem to invest. We invest a lot of confidence in the agencies, and we always had. And some are civil servants who serve Republicans and Democratic administrations. They know this field. But again, if they have questions, or you do, in terms of the regulation, there are comment periods. I think we don't actually use that comment period very well. We actually leave that to the outside interest groups and representatives and individuals to write in, but doesn't mean that Congress can't also say, we didn't quite mean this, I suppose, and really try and articulate that better. So I think there are opportunities that exist. But again, making sure that you have the expertise to be able to respond, and making sure that there are experts in the agencies who you can rely on, and because you want to do their jobs completely. The other, as I would say, is again, don't use reauthorization the way we could. We sometimes wait on reauthorization for years, or we just continue to say, okay, we don't have time, just let it go. I have one big one coming up. MACRA expires at the end of the year. Is there a real discussion we know should be going on about changes that can be made to enhance that legislation? There's a lot of bipartisan interest in it working, but it really, to just let it go another year or two or three could actually undermine a really important effort that's been passed by Congress. But it needs time and effort to actually get into what should change and what could improve that law. So I would use the reauthorization process and also ask for, we talked about this, a possible review of how a law has been implemented. What's the data? What's the evidence? What is it doing what we want it to? And you can do that. You can find out. Are people healthier as a result of what we did, or are they worse off? Are they spending more money as consumers, or they're not? Is, in fact, the air cleaner because we've getting rid of our efforts to do clean energy? Are we happy with what's happening? Is that working for us or for you and for the American people? That's something you could call on in law to say, I want to report back in a year or two, even before reauthorization, to be, how is this working, and how could we improve it if we need to?
Yeah. I appreciate that very much. Senator John Fetterman, Democrat, Pennsylvania, raised questions during the discussion on the Loper Bright Enterprises versus Raimondo case, which effectively ended the Chevron Doctrine, a Supreme Court precedent that for decades allowed courts to defer to federal agencies in interpreting unclear laws. Fetterman noted that Congress rarely writes perfect legislation. To build majorities, details are often left vague, and lawmakers cannot always predict future consequences. This creates situations where courts and agencies must determine the best reading of the law, and he pressed on what needs to be done both judicially and legislatively to address such challenges. Legal experts explained that courts are now required to fully interpret statutes on their own, relying on precedent, statutory canons, dictionaries, and other legal tools, rather than deferring to agency expertise. They emphasized that this is consistent with how courts already handle other areas of law, such as criminal statutes. Agencies, meanwhile, have already started shifting away from assuming Chevron deference, instead working harder to find what they consider the best interpretation of the law. Another key point raised was the need for stronger communication between Congress and the executive branch. Lawmakers were urged to clarify their intent when necessary and to make better use of existing mechanisms such as comment periods during rulemaking. These periods are often dominated by interest groups rather than lawmakers themselves, even though they provide a direct channel for Congress to shape regulatory outcomes. Concerns were also expressed about the weakening of agency expertise due to staffing cuts, which makes it harder for both Congress and the public to rely on agencies for accurate, informed implementation. Civil servants across administrations have historically provided continuity, but that capacity is being diminished. Fetterman and others pointed to the importance of reauthorization processes for major legislation. Too often, Congress allows programs to continue without updates for years, weakening their effectiveness. By using reauthorization to review how laws are working, lawmakers could strengthen programs rather than let them stagnate. Finally, lawmakers were encouraged to require periodic reviews and reports on how laws are being implemented. Data on consumer costs, public health outcomes, and environmental measures could show whether legislation is achieving its intended goals. Such reports would give Congress a clearer picture of whether adjustments are needed before reauthorization deadlines. The discussion made clear that in the absence of Chevron deference, courts, agencies, and Congress must each play a stronger role in ensuring laws are carried out effectively. For Congress, that means not only writing clearer statutes but also committing to active oversight and maintaining the expertise needed to respond when laws fall short of their purpose.